Mr. Jordan, I don't see the jail on the line. Are they dialing in?
They haven't logged on yet, too.
Okay, we'll hold. I also don't see any PDs. Hopefully they're at the jail. Okay.
They say they will be logging on shortly.
Thank you. And I know there was more on the pull sheet this morning, Mr. Jordan. Is it only 14? Are we gonna have an add-on? I guess I should ask Ms. Allen. Are there any add-ons?
No, Your Honor, we got one case was NOD.
Okay.
Uh, one person made bond Hamlin,
Uh-huh.
and the other two cases were transferred to the DA.
We had a
One
few
was
transfers this morning.
Okay. Thank you. Perfect.
And when I was going to the jail just a few minutes ago, I saw that position 3 made bond also after the calendar was sent out.
I'm sorry, Mr. Jordan, say that again. You said position 3 made bond?
Position 3 made bond. He posted bond.
Okay. Are the PDs at the jail? Attorney Ruff, who's your client?
Good afternoon. I've logged on for Raquel Ortiz. I think she's on a.
Okay.
I've got a case number here. Hold on. I've got an email about it.
We got her. She's here.
Okay.
All right. Mr. McLean, I see you. Mr. McLean, have you had the opportunity to interview all of your clients? You're muted. We can't hear you.
I believe that Henderson and Knight are upgraded, so I don't have to interview them. I was going to interview Ortiz, but as I just logged on, I think she's got private.
Yeah, she has private counsel. Attorney Ruff is here for her. Anyone else that you haven't interviewed?
I think that's it.
Are you here by yourself? And I see Miss McLeod.
No, I think
Are you
Cook's here.
Where's Mr. Cook?
Is
He's not here.
Oh, he's not on. Okay. Well, let's just start with mine and he'll come on, I'm sure.
Hope. All right, let's get started. I was trying to see if we could speed the interviews by doing it while we were going. Good
Sure.
afternoon, everyone. This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. I am Judge Melanie Williams, and today is September the 26th of 2024. All defendants, please pay attention. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel today. As you can see, this particular proceeding is being conducted over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch. When I ask if you understand your rights, that is what I am referring to. Those who receive a signature bond today will be reset further notice. Those who receive a surety or cash bond will be reset to the state all-purpose calendar on October the 10th, whereby bond and aspects of contact and other parts of the case can be reconsidered at that time. Is Miss Ortiz at courtroom 2?
Yes, I am.
Can we do her first? Okay, good afternoon, Miss Ortiz. Your case is 24 CR 00 6716F. You are charged with driving with a suspended license, knowingly driving on a canceled registration, no insurance, expired plates, obstruction, and obstruction 3 counts. You understand your rights today?
Yeah, as far as I have right to an attorney, right to remain silent.
Yes. You understand that?
Yes.
All right. Thank you, Mr. Howard.
First, jail is the recommendation.
It's obstruction, can't go through the jail. All right, Miss Allen.
Thank you, Your Honor. She does have no other prior criminal arrest, but her driver's history is extensive. I would note she's a public safety issue based on that. This is a case that occurred yesterday, the 25th. Police observed the defendant driving a Lexus at 575 Ponce de Leon. It was seen to have an expired plate. They ran the vehicle and verified that it has expired plate. It also was documented as having no insurance. The car was not registered. Traffic stop was initiated by officers. Stedham actually initiated the traffic stop. When he made contact, the defendant refused to lower her window. He opened the door to the car and her driver's license fell to the ground. He looked at that and realized that it had been suspended. And he told the defendant she would need to get out of the car. The defendant refused, locked the door, and requested a supervisor. A supervisor came to the scene, Sergeant Harris, who also tried to speak to the defendant. She, again, refused to follow verbal commands and get out of the vehicle. They needed to tow her car. She's not able to drive it. Just basic logistical things as it relates to the traffic stop and the violations. Another officer had to come. It was actually Captain Thomas, the third person who came. And after a 2-hour period of talking to this defendant, they had to break the window and remove her from her car. We're asking for a $3,000 surety bond total. I think she's got some already. I think that's what she already has, Your Honor, and just a requirement that she not drive. And no drugs, alcohol, or weapons. Thank you.
Okay. Mr. Ruff?
Your Honor, I think it's clear from the facts that Mrs. Ortiz was not driving a vehicle that belonged to her. It was not registered. I think at that moment she was arrested on a failure to appear up in Hall County as part of a traffic incident. She resolved everything up there and was not on probation or parole in any place when she left. That was a few months ago. I think this is the first incident from them. She didn't try to flee for the officers, and we didn't hear any information about the area where they pulled her over and whether that was safe. She obviously felt that one officer at that point in time of the evening, she was not safe and did request a supervisor, which I think at least the first request was made in good faith. As far as the facts afterwards, again, she didn't flee or attempt to elude the officers in any way while she was non-compliant with them. Ultimately, she was not violent. Did not get physical with the officers. Your Honor, I think that she would be entitled to a signature bond. This ultimately is a traffic offense and its underlying roots. And while we did need to do some investigation as to who the car belonged to and how she ended up behind the wheel, I think those are investigations that be conducted while the case is being set for further hearings in the future. She's not a danger in her actions to the community, in that, again, there was no violence. And obviously she doesn't need to be driving any vehicles, and that can be made clear without keeping her from freedom.
All right. In light of information before me, defendant's gonna get a $35 cash bond, which is $5 on each count. She's not to drive and have no alcohol, drugs, or weapons. Is there anything additional? All right, Mr. Ruff, does that conclude your business today?
It does, Your Honor. Thank you for your time.
All right, best of luck to you, ma'am. That concludes your case.
Your Honor, can you do the breakdown for that? Is that
It's $5 on each count. She has 7 counts, so it's she has to pay $35 to get out of jail.
Okay. I need my phone.
All right, who do we have next?
We go to position number 7, Ms. Harper.
All right, good afternoon. Ms. Harper, your case is 24 CR 006724B. In this case, you're charged with battery, family violence. You understand your rights?
The right to attorney and the right to remain silent.
You don't have to
Damn.
repeat it. You got it. Yes, that's it. All right, Mr. Howard.
Fourth arrest, 2022, no license conviction. 2019, driving without a valid license, no low. 2018, driving while impaired conviction.
Okay, thank you. Ms. Mokake, please proceed. You're muted.
Thank you. This incident occurred September 25th, 2024. I have that the incident location is 2657 Lenox Road in Atlanta. Officers arrived at the location and met with a Miss Virginia Curvo, who had bruises on her right bicep and also bruises on her hand. The victim stated that she was trying to take photos of her roommate, who is the defendant, in order to file an eviction when the defendant grabbed her by her arm, pushed her into the wall outside the bedroom, and then closed the door on her hand. Our office has spoken with Ms. Curvo, who confirmed that the incident location is her home and she was allowing the defendant to rent a room there to help her out, but the defendant has not paid rent since July. The defendant has been verbally abusive to her in the past, but this is the first time she has become violent. She states that she is in the process of filing an eviction, is in fear of the defendant, and also plans to file a TPO. She, of course, wants no contact and for the defendant to stay away. The defendant will need a one-time law enforcement escort to retrieve her belongings should the court grant that stay away. The state's recommendation is a signature bond through pretrial services, no further contact with this victim, stay away from the incident location, anger awareness, and no drugs, weapons, or alcohol while out on bond. I would ask the court to sound for the victim, Miss Virginia Curvo.
Sorry, Curbo is the last
I'm
name?
right here. Can you hear me?
Wait 1 second. Please, can Ms. Mokake say the name again for the record?
Curvo, Curvo.
All right, Ms. Curbo, if you'd like to make a statement, please raise your right hand. Do you swear and affirm testimony you give today be the truth to the best of your knowledge?
Yes, I do. Yes, I
All
do.
right. All right. And whether you disagree or want to add facts, that's not what I'm concerned with today. There'll be other proceedings regarding this case. This is just a bond hearing. I'm most concerned about your desires for contact with the defendant. What would you like to tell me?
I am afraid. My safety is at risk. I don't want to see her. She can go there to get her stuff, followed by a police officer, but my safety is at risk. Here are the bruises. Okay, I'm all bruised, you see? And my knuckles. I
Okay,
don't
so-
want her close to me.
All right,
No
thank you.
contact.
I appreciate you coming forward to make that statement. Mr. McLean?
Your Honor, I'm sorry, would the state repeat, not the conditions, but the main part of the recommendation again?
We asked
What?
signature bond.
SOB pretrial and no contact, one-time LEO escort.
We agree.
Okay. All right. Defendant is going to receive a $3,000 SOB through pretrial at level 1. She's going to take the 1-day anger awareness course. She's to have no contact with the alleged victim, last name Curvo. She can return one time with law enforcement to get any items. She's to have no alcohol, no drugs, no weapons as a condition of that SOB through pretrial services. Is there anything additional?
Nothing.
Can what's an SOB? I don't know.
If there's a victim witness advocate, can someone please chat Ms. Curvo? All right, someone will be in touch with you, all right?
Okay.
Best of luck to you, Ms. Harper. All right, who do we have next?
Your Honor, what was the amount? You said three?
$3,000 to $3,000. All right, who do we have next?
You could take up Miss McLeod's case. That'll be position number 2, Mr. Barber.
All right, Mr. Barber, please come forward. Your case is 24 CR 006718D. You're charged with simple battery and hindering someone attempting to make an emergency call. Do you understand your rights today?
No, man, I wasn't charged no simple battery.
No, let me just tell you your rights. Your rights, you have a right to remain silent. You have a right to an attorney, and I'm conducting this by video. I have apprised you of your rights. So we will go to Mr. Howard.
30 total. 2015 obstruction. 09 simple battery conviction. I stopped there because I know you don't like me to keep going.
I don't know if that's accurate. Was there anything else relevant? I guess not.
It
Ms.
was
Mokake
past
is-
09, so I
Yeah.
cut it off.
Understood. I'm sure Ms. Mokake will fill me in if there's something she feels is pertinent. Please proceed.
Your Honor, this incident occurred June 18th of 2024. The incident location is 2961 Randall Street in East Point. The victim in this case is Asharia Sessoms, that is Sessoms. He was at the defendant's residence when she opened a bottle of his liquor, which upset him. He then began cursing at her and told her to leave. The victim told him that she felt threatened and she said that she was going to call the police. She exited the residence and the defendant proceeded to follow her. He then grabbed her by her neck and snatched her phone from her hands. She also states that the defendant pointed a gun at her from his front porch. A friend of hers was able to go into the house and get her phone from the defendant. After she got her phone, she left the residence and proceeded to call the police. Our office has had a chance to speak with Ms. Sessoms, who states that she used to live across the street from the defendant a long time ago, and she would go over there to buy the things that he sold. She confirmed the events in the warrant. She stated the defendant was grabbing her by her neck because he wanted to get her phone, and she had stated that she was going to call the police. Once she released the phone, the defendant then let go of her neck and went back into the house. She confirmed again that the defendant did retrieve his firearm from the house and did point it at her. She states she hasn't spoken to the defendant since this incident. Based on the allegations in this case and the defendant's 30 arrest cycles, the state's recommendation is going to be for a $2,000 surety bond on the simple battery, a $1,000 surety bond on the hindering 911 call, no further contact with this victim, anger awareness, and no drugs, weapons, or alcohol while out on bond. Particularly, he is not to have any firearms. I would ask the court to sound for the victim, Ms. Maria Sessoms.
All right, is Ms. Sessoms on the Zoom conference and wishes to make a statement? If so, please turn on your camera and raise your right hand. Okay, Ms. McLeod, please proceed.
Good afternoon, Your Honor.
Good afternoon.
I would ask the court to consider a signature bond for my client. He has not been in any kind of problems with the law since I believe I heard 2009. He is 62 years old. He's the father of a 7-year-old daughter. And he denies the allegations made by the complaining witness, Your Honor. Based on what the state is saying, it looks like she came in his house and essentially was not being a good guest, and he asked her to leave and she became upset. He denies that he put his hand on her or anything else that she's alleging, Your Honor. And he's a little bit concerned that he has been locked up behind this kind of false allegation. Nothing further, Your Honor.
All right, defendant is going to receive a $3,000 signature bond through pretrial at level 1. It's $2,000 on the simple battery, $1,000 on the hindering the phone call. He is not to have any contact with the alleged victim, have no alcohol, no drugs, no weapons. Is there anything additional?
Nothing additional, Your Honor, from the defense anyway.
Were you saying anything, Ms. McConaughey?
No, nothing, Your Honor.
All right. Best of luck to you, sir. That concludes your case.
Thank you, Your Honor.
Conclude your business, Ms. McLeod.
It does.
Take care. Stay safe. Have a good afternoon.
You too. Thank you.
Bye-bye. All right, who do we have next?
Next, we go to position number 9, Mr. Morales.
All right, Mr. Morales, your case is 24 CR 006715G. You're charged with simple assault, family violence. You understand your rights? Is that a yes? You understand your rights? All right, Mr. Howard.
Third arrest, 2022 battery DV. That's open in state court. Well, he has an open one in state court, 24 CR 006375G. 2022 possession of cocaine with intent. That's it.
All right, Ms. Allen, please proceed.
This incident happened on September the 25th at about 9 a.m. Police were called 212 Peachtree Avenue. That's the location where this defendant has just been ordered to stay away from and have no further contact with the victim in this case. He was released on bond September the 10th for an open battery family violence. That's the case pretrial just mentioned. His $1,500 good bond requires him to stay away and have no contact, as well as have a BHET.
Was that set by me, Ms. Allen? Does anybody know?
Judge Morrow.
Okay.
So yesterday, when police went to that location, the same victim, the brother of this gentleman, Mr. Morales, reported that he was in fear the defendant was going to hurt him. The defendant had thrown an object at him. He said he woke up and heard the defendant striking the walls inside the residence with a large metal stick. He went outside of his room, went to the bathroom, and when he exited the bathroom, the defendant threw the object at him, almost striking him. The last time we were in front of the court for SEA, it was made clear that the defendant lives with his parents and his brother, so his brother's not the only person in this residence, and that there was a large concern for his behavior due to either an MH issue or substance abuse issue. He was specifically ordered to undergo an evaluation and to have no contact, and he's clearly in violation of that bond now. He's also made contact from the jail with the victim, Your Honor. We did speak to the victim in this incident, his brother. He reported that he doesn't want contact. Again, he's asking for no contact. He confirmed what occurred in the warrants. He said that there's a drug use problem and this defendant becomes violent and is afraid that the defendant is going to hurt someone in the family more so than he already has. We're asking for a $2,000 cash bond, Your Honor, an ADET and a BHET before being released from jail to follow any recommendations from that evaluation. No drugs, alcohol, or weapons. Stay away from the location again, and no contact with the victim in this case. Thank you.
I'm sorry, and the victim is Mr. Morales as well?
Yes, in this case, same victim.
All right, I'm sounding from Mr. Morales, not the defendant, but the brother.
It's Mr. And he's not on the Zoom. He has a job. He's working, but we have been in
Not
touch
here.
with him. Yes.
Okay, I wanted to sound just in case. All right, I have sounded with victim in accordance with Marcy's law. Mr. McLean, please proceed.
One small correction, he was hitting the wall with a metal stick according to the allegation, but then the allegation said that what he threw was a wooden stick. So
Oh, I apologize. A different object.
Not much of a difference, I understand. But Your Honor, we leave this in discretion of the court, given all the history of it. I've talked to the family, I've talked to him. He needs some evaluations, of course, and we trust the court to reach a fair solution for this bond hearing.
All right, thank you. Defendant's going to receive an $8,000 surety bond. He's to have absolutely no contact with the alleged victim in this case, undergo a BHET and an ADET. He's to have no alcohol, no drugs, no weapons, of course, should he be released. And he is to, was there a stay away? The stay away is a 12 Peachtree, and he's to stay away from the address 12 Peachtree as a condition. And as a reminder, he's going to all-purpose on the 10th as well. All right, best of luck to you, sir. That concludes your case.
Next we can go, ACDC. We can go to ACDC.
All right, who do we have at ACDC?
Good afternoon, Judge Williams. This is going to be position number 13, Ms. Walker.
All right, thank you. Good afternoon. Has ACDC heard that right?
No, they did not, Judge.
All right, that's okay. Good afternoon, all defendants at ACDC. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel, and I am conducting this hearing by video today. Ms. Walker, your case is 24 CR 006725E. You're charged with simple battery family violence. Do you understand your rights today?
Yes, Your Honor.
All right, thank you. Mr. Howard?
Second arrest, 2018 battery DV, dismiss.
All right, thank you. Ms. Allen?
Thank you. This is an incident that occurred on the 24th, very early in the morning between 1 and 8:30 a.m. Police were called to 2314 Bryant Drive in East Point. There, outside the location, they met with Christian Bryant. He's a 29-year-old adult child of this defendant. He reported that he'd been smacked in the face by his mother, who has a drinking problem, and got angry with him because he wanted her to turn the music down. It was past midnight. He was smacked in the face. He held his mother down and put her on her bed and left. This was observed by the other adult child in the home, Chase Walker, who's 23 years old. They both reported to the police that there'd been a prior incident. That's the 2018 arrest that you just heard of, that Cobb County Police in that situation had been called to their house, and that when they lived at another address in East Point, this was an issue as well. The victim was seen to have, or no, he didn't have any visible injuries, but the defendant did complain that she'd been pushed into a wall and she had a head injury, but when she was taken to the hospital, she declined to have a CT scan. She did admit drinking, and she said she'd been manhandled by her son. We did speak to the victim, the initial victim, Christian, today. He confirmed the events in the warrant. He did contradict himself and say that this was the first time that a incident like this has happened, when that clearly isn't the case based on just the documents that we've reviewed and the evidence, but he claims he's not in fear. This is obviously a difficult situation. We'd be asking for $1,000 SOB through pretrial, Your Honor, no violent contact, and no drugs, alcohol, or weapons. We'd ask that that be through pretrial with random screens and some kind of ADET, if that would be helpful. Thank you.
All right. I'm inclined to do that, but I'm gonna hear, what's the alleged victim's name? You're muted, Miss Ellen.
Christian and Chase Walker are her sons.
All right, is Christian or Chase Walker present? I wish to make a very brief statement. All right, I've sounded. I don't hear or see anything. Ms. McLean, I'm inclined to give your client a signature bond through pretrial, but I would require the random screens. Any objection to that?
No objection, Your Honor.
All right.
Trying to reach Mr. Cook. I'm unsuccessful, but that sounds fine.
All right. Defendant will receive a $2,000 signature bond through pretrial services at level 1. She's to undergo random screens. And she is to have no further violent contact with the alleged victim in this case. Is there anything additional?
I would like to add something.
I don't think you should. You have a right to remain silent, and Miss Allen is listening. I don't want anything you say to get used against you. I've given you an opportunity. I've given you a signature bond, okay? So you can sign your own bond, okay?
I did have a CAT scan though.
Okay, I don't want you, just, the facts of the case will be developed at another day. I'm letting you out of jail, okay?
Your Honor, I'm sorry, I was blown off the air, and in Tucker, if a bird flies by a power line, we get knocked out. So, and yes, okay, fine. I wouldn't say anything, but I'll just say on the record, it is ridiculous that she is here, and you can tell that from the.
I understand. I
Okay.
understand. I understand your feelings about it. Let's put it that way.
Ma'am, you will have time when you're in a forum that will weigh the elements, all the elements, to have your story told. As I told you,
this is just a bond hearing. There'll be another day where you can get your full side of the story out. We just have a lot, and this is just an initial hearing, okay? And your attorney can explain that further, but I am letting you sign your own bond to get out of jail, okay?
Let's start there, and then you'll have another. Well, you have another attorney signed to
is frozen. ACDC is frozen. They're not hearing anything. Oh, now they're back. All right. It was frozen for a second.
Now we talked about it, and I'm outraged that you're here, but there'll be another time and place to express that outrage. But mainly the facts will win out, and I think you'll be fine. But let's just get you out of jail.
All right. Best of luck to Miss Walker. Who do we have next?
Next, we can go to position number 6, Mr. Hare.
All right, Mr. Hare, your case is 24 CR 006723G. You're charged with battery, family violence, obstruction, and making terroristic threats. You understand your rights?
11 total. 2011 battery out of California. It's battery on spouse. 2010 disorderly conduct dismissed.
Okay. Ms. Mokake, please proceed.
Yes, Your Honor. This incident date is September 25th, 2024. The location is 600 Waynes Court in Atlanta. The victim is Kevlin Hare, who is the defendant's daughter. The parties were having an argument about the defendant's drinking habits when the defendant struck his daughter in the face, causing a bruise and a laceration. Officers found the defendant locked inside a room in the residence. They asked him multiple times to unlock the door and come out, but he refused to do so. Instead, he just screamed profanities at the officers and told Officer Skinner that he would go to his truck, get his firearm, and shoot him. Eventually, the defendant did come out of the room and was arrested. Our office has had a chance to speak with the victim in this case, who confirmed that they all lived together at the incident location. She confirmed the events in the warrant and stated they've had arguments before, but this is the first time the defendant has been violent. She states she's not in fear of him and is okay with contact. She says that she's also okay with the defendant coming back to the residence. The state's recommendation would be $1,500 on the battery, family violence, and $500 on the willful obstruction of law enforcement officers, and $1,000 on the terroristic threats. No further violent contact with this victim. Anger awareness, maybe some random alcohol screens would be appropriate. No drugs, weapons, or alcohol while out on bond. I would like to sound from Ms. Kevlin Hare. She indicated earlier that she would be on the Zoom.
All right, Ms. Hare, if you're present, please unmute your screen, turn on your camera, raise your right hand. Do you swear and affirm the testimony you give today be true to the best of your knowledge?
Yes.
All right, what I'm most concerned with, as you've heard me give instructions before, this is just a bond hearing, so the defendant is entitled to a bond today. I'm most concerned with concerns you have for your safety and whether you wish to have contact. In light of those instructions, what would you like to tell me, Ms. Hare?
I don't want him to come back because my mom is still here and he is probably going to still yell at her, but he doesn't have anywhere else to go. So
Okay.
I really don't know what to do.
Okay, I understand this is difficult. Do you have concerns for your personal safety?
No, it's just me protecting her because he gets mad at her.
All right. Thank you for coming to court, Ms. Hare. I understand this was difficult, but the court does appreciate you making an appearance today, okay?
Okay.
All right, Miss. I'm sorry, Ms. Mokaka.
I was just saying, maybe given what she just stated, maybe, you know, she can have contact with her dad as long as it's not violent, but he might just need to stay away from that residence for some time. This just happened yesterday.
We're gonna think about that, all right? Thank you. Mr. Clerk, please proceed.
Yes, Your Honor, my client is 67 years old. He's been in this house, I think they've been about a year. He is not working at the moment. He had a security job interview today, or it may be early in the morning. He is a 10-year veteran of the Air Force. He denies the allegations as stated in the warrant. And we would ask, given the, I know given the charges, he's probably restrained from a signature bond, but we would like, given he has no income and he doesn't know where he's going to go, so we would ask for a low surety bond, very, very low surety bond, because he's dealing with zero money and no place to go. Nothing further.
Okay. I'm thinking. I'm sorry, Mr. Howard, I hate to make you run it back. 2011 was last arrest?
Yes.
And it was disorderly?
Well, last violent arrest anyway, but it might have been the last. It was the last. No, it was battery on a spouse. It was dismissed out of California.
And that was
Your Honor, if there's no return to the resident, and
I don't know
know
if it was.
I'm sorry, Mr. Howard.
I'm not sure if it was dismissed, but that was the last arrest in California.
In 2011. Okay.
If
sorry, go Mr. Cooks. Go ahead.
No, I'm sorry. If the condition is no return to the residence, he has nowhere else to go, but also no violent contact. I know we don't like to use this too much, but maybe a low cash bond would be a possibility.
Yeah, and I think I would emphasize that we would be requesting a stay away, given that his last arrest was a violent arrest against a spouse.
I got it, Ms. Mokaka.
I understand the stay away.
Stay away.
I understand stay away is probably in the mix. I wasn't disregarding.
Yeah, I've got it. Let's put it that way. Okay. What we're gonna do is defendant's gonna get a $3,000 signature bond through pretrial services per judge at level 1. He's to have no further violent contact with the victim. However, he is to stay away from that location. The address and the stay away conditions can be modified at a later date, but for now he needs to stay away. He can return one time with law enforcement to get any items he may need to collect. He is also going to take the 1 day, actually he's going to take a 2-day anger awareness course as a condition of that signature bond through pretrial. Is there anything additional?
No, Your Honor. Thank you.
All right. Best of luck to all parties concerned.
Thank you.
All right. And who do we have next?
Position number 1, Ms. Baker.
Thank you. Ms. Baker, your case is 24 CR 006717F. You're charged with 2 counts of battery in this case. You understand your rights?
Yes.
All right, Mr. Howard.
Arrest. I got 2019 shoplifting.
Oh, Mr. Jordan, something's wrong. It's supposed to be something else.
Oh, I'm sorry. My volume had went out. What was the last case we just did?
We just did Mr. Hare, and it's 3,000 signature bond,
And what was the breakdown on the each?
1,000 each count.
Okay, thank you.
Thank you, Mr. Jordan. My apologies. Mr. Howard, please, I'm sorry, please proceed.
2019 shoplifting PTI, 2018 obstruction conviction, 2017 obstruction simple battery conviction. That's it.
Okay, thank you. Ms. Mokake, please proceed.
Yes, Your Honor. This incident occurred September 25th. The defendant got into a fight with a Miss Seneca Clark, who is her boyfriend's ex-girlfriend. Ms. Clark came to Mr. Heslop's residence and states that when she arrived at the location, the defendant charged at her and attacked her. Ms. Clark's hair was pulled out. She had a busted lip and a bite mark on her arm. When interviewing Mr. Heslop, he states that Ms. Clark came to the residence and was upset that he was with another woman, and Ms. Clark also had a hammer which she swung at him. A witness by the name of Sunshine Santiago states that Ms. Clark pulled the defendant's hair, and that may be how the fight began. Ms. Clark was also arrested for aggravated assault and battery. Given the facts of this case, the state's recommendation is going to be for a signature bond through pretrial services, no further contact with Ms. Seneca Clark, anger awareness, no drugs, weapons, or alcohol while out on bond.
You said a signature bond?
I did.
I'm going to argue for the same thing, Your Honor.
I'm not
No,
sure.
no. Somebody comes at you with a hammer, you ought to be able to do something.
Okay. Who's it?
Not
Let me hear from the alleged victim. Is Mr. Clark, I'm sorry, Miss Clark. Is Miss Clark present?
No, she's
Go ahead, I'm
incarcerated.
sorry.
She
was
wasn't
arrested.
here. She was arrested as well?
Yeah.
Yes, she was arrested and charged with
That's a
aggravated.
dual arrest. Okay. All right.
But for aggravated assault, because she had a hammer.
All right, true. All right, Mr. Clark and Ms. Mokake. It may have to be per judge, but defendant will receive a $2,000 SOB through pretrial at level 1. She's to have no contact with Ms. Clark, have no alcohol, no drugs, no weapons. Is there anything additional?
No, Your Honor.
All right. U.S. signature bond, Ms. Baker. Don't say too much. If you have a question about the bond,
Miss Clark, don't say anything. You get out
Baker.
later and fight another day. Your Honor, what was the amount of the
It's
bond?
2,000, 1,000 each count.
Thank you.
All right. Best of luck to Ms. Baker. You have a sign-on bond. Who do we have next?
Thank you, Judge Williams.
Thank you. ACDC can be excused if they're complete.
Position number 4, Mr. Freeman.
All right, Mr. Freeman, your case is 24 CR 006720A. You're charged with 2 counts battery family violence. You understand your rights?
No.
All right, Mr. Howard.
17 on probation out of Douglas County. False imprisonment. Got a 2024 FTA, 2023 probation, 2019 simple battery DV conviction. That's it.
All right, thank you, Ms. Mokake.
Yes, Your Honor. This incident occurred at 62 Harwell Road Northwest in Atlanta on December 26th of last year. Officers were dispatched to the location in response to a domestic dispute. Upon arrival, they met with the victim, Kyra McCarty, who told officers that her boyfriend, the defendant, grabbed her neck with his hand and held her down to prevent her from getting up. The victim also had visible bruising on her left eye, forehead, and leg. The bruising on her neck was consistent with bruising from fingers when a neck is squeezed. The parties also share a child together. When officers spoke with the defendant, he stated that the victim is light-skinned, so she bruises very easily. The state's recommendation, given the allegations in this case and the defendant's criminal history, which includes FTAs, open cases, and violent convictions, is a $2,000 surety bond on each count of battery, no further contact with this victim, stay away from the incident location, an FVIP or anger awareness, no drugs, weapons, or alcohol while out on bond.
All right.
And I would ask the court to sound for the
Is
victim.
Ms. McCarty present, wishes to make a statement? If so, please unmute, raise your right hand. Hearing, seeing none, Mr. Cook?
Yes,
I'm
Your
sorry,
Honor.
what was the name?
Go ahead, Ms. Fowler.
What was the name you called?
I'm sorry.
Are you Kyra McCarty?
No.
Okay, then that's not you. All right, Mr. Cook, please proceed.
Oh, okay. Mr. McCarty, this was Freeman. Well, wait a minute. Okay, I'm sorry. Okay, I'll sorry, Your Honor. Didn't mean to take over your courtroom.
That's fine. Please proceed.
My client is 23 years old. He's lived in town in this area his whole life. We understand the background, and I can only add that he is not working, has no income, but he has been here in the area 23 years. So I don't really think he's a threat to the community. I don't think he's a threat not to show to appear unless I miss some FTAs in his background. We would ask for the lowest possible surety bond. We have no or that would cause him some problems. We have no problem with a no further contact or no further violent contact or no further contact and a stay away. We just would like him to be able to get out of Rice Street as soon as possible. And we'd be asking for a low surety bond. And we would object to the FVIP too.
All right, defendant's gonna receive a $2,000 surety bond, $1,000 on each count. He's to have no contact with the alleged victim, stay away from that incident location, have no alcohol, drugs, or weapons, and he's going to all purpose on the 10th. Best of luck to you, Mr. Freeman. That concludes your case at this time. Who do we have next?
Petition number 12, Mr. Sumlin.
I'm sorry, say that name again.
12, Sumlin.
All right. Wow. All right, Mr. Sutherland, your case is 24 CR 006727Y. In this case, you're charged with battery, family violence, and 3 counts for cruelty to children in the third. You understand your rights today?
It's battery, 2 counts, and 1 simple battery DV, right?
Oh, my apologies. 1 count battery, 1 count simple battery, and 2 counts cruelty. I read that incorrectly. Do you understand your rights? Is that a yes, Mr. Sumlin?
13 total. 2021 simple battery, cruelty in the third out of Clayton County. 2019 battery DV arrest. 2018 simple battery. 2017 simple battery DV cruelty to children. That's it.
Thank you. Ms. Allen, please proceed.
Thank you, Your Honor. This is an incident that occurred on the 24th of September. Police were called at about 8 p.m. to 3261 Washington Road in East Point. There they met with the victim. Her name is Crystal Thomas. She was seen to have swelling on her forearm. She reported that during an argument, the defendant struck her. They were together in the bedroom. He became angry and left the bedroom. He walked down the street to the store, and when he returned, they continued to argue. Her children were present, an 8-year-old and a 15-year-old in the home. When he came back from the store and continued arguing with her, he called her names and he struck her in the face with his open hand. The children heard this. They came running and crying, asking about why the defendant was hurting their mom. In addition, he kicked the dog across the room. He was arrested. Those are the basis for the charges, Your Honor. My understanding is, based on our conversation with Ms. Thomas, that she is pregnant and they live together. This defendant should have a felony battery case in front of you today. He has 3 prior family violence battery convictions against a different victim. I requested a transfer today and have not heard back. He also has called this victim 3 times from the jail already. When we spoke with Mrs. Thomas, she said she's not in fear of the defendant and she wants to continue to have contact with him and he can come home. The state disagrees that that's the best choice at this point. She's got 2 small children who not only witnessed this assault on her, but were visibly upset as a result of it, and they should be able to be safe in their home without violence, especially perpetrated by someone who already has 3 prior convictions for the same type of behavior. So we're asking for a $4,000 good bond, Your Honor, in order to stay away from the location at 3261 Washington Road, have no contact, have no drugs, alcohol, or weapons, and no firearms. Thank you.
And no charge for the dog, Miss Allen? Okay.
I mean, I can read.
I'm not suggesting it. I just am
It's
curious.
absolutely applicable. You could find probable cause. It is a misdemeanor crime.
I just didn't hear something. All right.
I ran out of time.
All right, Ms. Thomas, please raise your right hand if you wish to make a statement and unmute. Do you swear and affirm testimony you give today be true to the best of your knowledge?
Yes, ma'am.
All right. What would you like to tell me?
He's not usually a violent person. He's very good towards my kids and me. He does not typically act out or act violent whatsoever. This is it's just been one incident, was one bad day.
All right. I appreciate you coming to court making that statement. Mr. McLean? You're muted,
sorry?
Mr. McLean.
Right?
We
I
can't
thought-
hear.
I
There
thought
you
I
go.
hit- There we go. Given her statement, I would ask the court, of course, to consider no further violent contact. However, I would also advise my client that statistically speaking, we would decrease the likelihood of anything in the future going wrong if, in terms of allegations, if they could perhaps make other arrangements. However, that's his personal business, and I will refrain from giving advice there. Your Honor, we ask the court to consider a signature bond. He is currently able to make only a small bond, and he is 35 years old. He's local. He's born in Atlanta. He went to high school here. We would ask the court to consider a signature bond or a $1,000 or $2,000 surety bond at the most.
All right, defendant is going to receive a $3,500 surety bond broken down as follows: 1,500 count 1, 500 count 2, 500 count 2. 500 count 3, and 1,000 count 4. So that should equal 35, if my math is correct. He's to have no contact with the alleged victim and stay away from that location. He can return one time with a member of law enforcement to get any items. And he's to have no alcohol, no drugs, no weapons. And again, contact and other aspects of the case can be adjusted or revisited at the state all-purpose calendar on October the 10th. Best of luck. I'm sorry, Mr. McLean.
That's October 10.
Yes, 10/10. So
Thank you.
he's going to SAP that day.
Yes.
All right. Best of luck to you, Mr. Sumlin, and to all parties concerned. The case is now concluded. Who do we have next?
I don't remember about count 4. That ain't got nothing to do with you. She talking about me.
We can go to position number 5, Mr. Galette.
All right, Mr. Galette, your case number is 24CR006721E. In this case, you are charged with criminal trespass and damage to property. You understand, right?
Yes, ma'am.
Thank you for that. Mr. Howard?
It's Gillette, right? 10 total. 2024 trespass. That's open. Got a on probation for trespass out of state court. 2024 trespass conviction, 2024 ag assault dismissed. 2023 probation put out of DeKalb County for assault.
Okay, thank you. Ms. Mokake?
Yes, Your Honor. This incident occurred at 1374 Murphy Avenue Southwest in Atlanta. That is, I believe, Gateway Capitol View Apartments. Officers received a call from Officer Christopher Exum, who advised that the defendant was hitting the vehicle belonging to Beverly Howard. Mr. Exum told the defendant to stop, and the defendant proceeded to strike the windshield while he was screaming incoherently, then proceeded to leave the location. The defendant caused about $350 worth of damage to the victim's vehicle. Our office has had a chance to speak with Ms. Beverly, who states that she does not know the defendant. She confirmed the incident location is her apartment complex, and her car was parked in the parking lot while she was inside and this was occurring. She states she wants no contact with the defendant and wants him to stay away. He currently has a $1,000 surety bond, and we ask that that remain as it is. You have no further contact with the victim. Stay away from the incident location. And also BHET, given that his behavior was very strange to strike an unknown person's vehicle and then scream randomly in the process of doing so. No drugs, weapons, or alcohol while out on bond.
I'm sorry, her name was Beverly.
Beverly Howard.
All right, is Ms. Howard present and wishes to make a statement? All right, hearing, seeing none. Mr.
She's
Cook?
here. She was waving her hands. I don't know if she knows how to unmute.
Okay. Very quickly, if you wish to make a brief statement, please hurry up and figure that out.
She seems to be trying to talk, but I don't think she's saying that she can't figure out how to work the Zoom.
She's gonna figure it out, Miss Howard. Try to press a button that says unmute so we can hear you. Okay, while she's trying to work it out, Mr. Cook, please proceed.
Yeah, we understand the allegations and whether they're exact.
Got it.
Oh, okay, thank you.
No, go ahead. Finish, Mr. Cook.
No, and
Yes.
No, Miss Howard. No, wait 1 second. Go ahead, Mr. Cook.
no, whether they're exact or not, we understand the allegations, and that's going to be more or less the basis of the bond. So, we have no objection to. We would ask for a signature bond. I will tell you, he's on SSI, and I'm not even sure that has come through yet. We'd be asking for a signature bond at whatever the level the court deems appropriate, but we have no objection to a BHET.
Okay. All right. Ms. Howard, please raise your right hand. Do you swear and affirm the testimony you give today will be a truth to the best of your knowledge?
Yes.
All right. Well, what would you like to tell me?
Yes. He had caused me so much heartache. He caused me to spend money that I don't even have. I had to pay $350 to get my windshield replaced. Then I lost about $1,000 because I couldn't get to work because of my windshield. And I'm going like, okay, I don't bother nobody. I stay to myself here, and I treat everybody with respect and nice. So why is this guy all of a sudden want to crack my window? I mean, at first it makes me felt like, do this guy know me? Did I do something to this person or what? But he had cost me so much money that I don't even have. I had to borrow money to get my windshield replaced in order to make it to work today.
I understand, Ms. Howard, and I appreciate you coming to court to make that statement. And I'm sure this is just a bond hearing. There will be other hearings at a later date where the facts can be further fleshed out. In light of the information before me, the defendant's $1,000 surety bond will stand. He's to have absolutely no contact whatsoever with Miss Howard, and he is to stay at least 1,000 feet away from that location. He's to undergo a BHET and have no alcohol, no drugs, no weapons as a condition. Is there anything additional? All right. Best of luck to all parties concerned. Who do we have next?
We can go to position number 3, Mr. Crawford.
Oh, I thought Mr. Crawford made bond, no?
Not sure, Your Honor. They,
He did. It's posted on the
Okay.
jail.
I see
That's
that.
kind of
I
that's
saw
kind
that
of
3 is,
important. Okay.
all right,
Yeah.
I saw that 3 is already made bond. Is that correct?
It is. It's posted on the
Did
jail.
did they withdraw an
Okay.
earlier bond?
He's already bond has been posted, so he should be processed out shortly, I guess, if he doesn't
Okay.
have other holds. Mr. Crawford, you've made bond in this case, though.
They came off the bar. They came off of it because pre-trial I had a sentence amount through pre-trial.
Okay, Mr. Crawford, let me speak. I think.
Nah, let me chime in. I got it.
Okay, thank you, Howard.
He bonded out, but they came off the signature bond, so he's going to sit for that felony. So, I mean,
But this case is not the case that's holding him, correct?
correct, but he probably ended up going to SAP though. You might want to just set him for SAP though, just so he can keep up
I
with
don't,
it.
but if he already made bond, I can't. I cannot,
mean,
Mr. Jordan.
I'll put him on the calendar because it looks like it's a felony.
Yeah, I think it's
Okay. So his case is gonna go to SAP, but this case, this particular misdemeanor is not holding him in. He's made bond already.
okay.
All right, so this case is reset SAP 1010. He's made bond.
Mr. Howard, quickly, he's got he's got a felony with the bond.
He got a UJR and felony from what it
Oh,
showed.
really? Okay,
Yeah.
but you came off that.
Yeah, they came off it this morning.
Okay.
When he got
Could
rearrested.
I ask the charge just for paperwork?
I think it's theft by taking. It's no bond though, but I think it's theft by taking.
Okay, so he's sitting there because of a UGR that you came. Okay, well, I guess he can go SAP. I don't know why I couldn't.
Yeah, it says theft by receiving stolen property.
Okay, so but this case is not holding him. So he's all right.
Okay.
All right, who do we have next?
I'm sorry, I got confused. Does he have a bond set for this one?
Yeah, he's already made it.
Oh, he's made it. Okay.
He's made bond for this case. This is not the case. That's
my higher ups like paperwork, so I gotta.
I understand. I like paperwork too, but he made bond for this case. It's been
Thank you,
posted already.
Thank you, Your Honor.
All right. Can we move to the next case?
Can they set me a cash bond to pay for the bond that they gave me a signature bond on?
I can't do anything with that one. That's not before me today.
Have to show up in Odyssey that it has.
All right, who do we have next? We still have position 8 and position 11.
Let me go to position 11.
I'm sorry, we can't hear you.
Position 11.
Okay, thank you. All right, good afternoon, Mr. Robertson. Your case is 24 CR 00678. I'm sorry, 6728Y. You're charged with 2 counts battery family violence and 2 counts of cruelty. You understand your rights? All right, I'm assuming that's a yes, Mr. Howard.
11 total, 2024 battery on probation for that as of June. 24 CR 000563Y. 2023 simple battery DV arrest and some probation violations. That's it.
All right. Ms. Allen.
Thank you. The defendant did just plead guilty on June the 25th of 2024 in 24 CR 000563Y. That's a battery family violence against the victim in the current case as well, Your Honor. So this should be a felony, and he is currently under sentence for a battery family violence against her. The sentence and disposition requires no further violent contact. Oh, actually, I think as part of the plea agreement, it was dropped, the family violence was dropped, so it's just battery. And he's to not have any violent contact with his wife as a result of that. Oh, I think he pled nolo too. Isn't that interesting? So in June, he pled nolo to a battery against his wife, who is the victim in today's case, and another simple battery against her that was open was null prost at the same time. He has a conviction for armed robbery out of DeKalb from 2024, parole violation subsequent to that, and arrest for aggravated battery and burglary, as well as felony attempt to commit a felony conviction somewhere. This incident just occurred on the 25th at 8 p.m. Police were called to 1829 Campbellton Road, apartment A12. They were called because his wife, Lynette, the victim in this case, was upset. He was beating their child too hard. The little boy's name is Amari Roberson. When police arrived on scene, they spoke to Amari, who said his dad beat him because the neighbor's daughter said he was being a bully. They didn't see any visible injuries on the child at that time, and they told mom that assaulting your child and beating them too hard is a civil issue. Mrs. Lynette spoke to police after she talked to them about her son. Her daughter, Megan, was also present. She was seen to have welts on her face as well as bruising on her arm, and she reported that at the same time on this day, the defendant, her husband, argued with her. I don't know if it was before or after he beat their child, but he slapped her and grabbed her very forcefully by the neck. We did a strangulation assessment, and she reported that she thought she was going to pass out. She experienced shortness of breath and dizziness, as well as blurry vision. She also reported that while strangling her, and again, in the presence of their two children, Megan and Omari, he said that he was going to kill her and that the only way she was going to leave the residence was if she died. After he was arrested, Your Honor, his family came to the residence and harassed her and said they were going to call defects on her. So based on the Ayala factors, the risk to reoffend, the risk to intimidate, actually, this is a continuing crime. If after his arrest, he's calling her from the jail, I think we've already got 3 calls, and he's harassing and intimidating her through third parties. So based on his prior history, his multiple violent convictions, including a prior conviction against the same young woman, and the fact that this occurred in front of their children, we're asking for a $4,000 cash bond, absolutely no contact with Lynette Roberson or the 2 children, Megan and Omari, to stay away from the location, 1829 Campbellton Road, apartment A12, no drugs, alcohol, or weapons, no firearms. Your Honor, he may need a one-time police escort, and we would request as well that no contact specifically indicate and include that includes no contact through third parties. So the defendant's family does not need to be making contact with the victim and the children. Thank you.
All right, and I'm sounding for, is it Lynette Roberson?
Lynette Roberson, yes, Your Honor. Thank you.
Is Lynette Roberson present, wishes to make a statement? Has your office spoken with her, Ms. Allen?
We have, Your Honor, and we have also requested this case be escalated up to the DA's office as a felony just based on multiple.
I'm here. I'm here. I'm here.
All right,
I'm
if
here.
you'd like to make a statement, please turn on your camera, raise your right hand.
Okay, let me turn my camera on.
Do so quickly,
I'm
please.
here.
All right, do you swear in the, please raise your right hand. Wait, do you swear in the firm
It's my
testimony?
right hand.
Okay, do you swear in the firm testimony you give today be true to the best of your knowledge?
Yes, ma'am.
Okay, and you've heard me give instructions before. I'm most concerned
Yes,
about
ma'am.
what you have for your safety and desires for contact. What would you like to tell me?
I'm all over it. I don't want to deal with it no more. I'm tired. I can only take so much. I'm tired. This man don't had a gun to my head. Oh, the family just came yesterday. They came and got his car and found the gun. They pulled the gun. He's called them from jail. Told him what the gun was. He normally keep the gun up under his bed. I'm tired. I don't know what else to do. At this point, I don't want him around me at all of my kids.
He got my other son. They got it. They was out here acting a fool yesterday. They got my other son. That's fine. He came to an agreement that he can stay with him due to the fact that because Sean is very disrespectful. They got my baby so messed up. It's crazy, but it's okay. I'm going to get him back. Right now, I got to focus on me and my kids. I can't keep taking this. It's not going to work. I'm tired. I'm tired. I'm tired. Know what else to do.
I appreciate you coming to court and making that statement. All right. Okay. Mr. McLean.
Your Honor, we would ask the court to consider $1,000 or $1,500 or as much as a $2,000 surety bond in light of the preceding. Your Honor, he works full time. He's 37 years old. He is local, and he won't be missing court. He won't be ignoring court.
All right. Defendant is going to receive $1,000 cash bond. It's going to be $250 on each count. He is to have no contact with the alleged victim in this case and stay away from that address on Campbellton Road. Additionally, he is not to contact the children or have contact with the children or the alleged victim in this case, and he is not to contact her through third parties, social media, or any other means. He is absolutely to have no contact whatsoever through any means. He should not even send her a letter. Additionally, he's to have no drugs, no alcohol, no weapons, and he's going to all purpose on the 10th. Is there anything additional?
Nothing.
All
Would
right.
request a order that includes surrendering any firearms, Your Honor.
All right. Yes, and including that surrender of the subject firearm in this particular case. Mr. Jordan has a question. I've done something wrong. What is it, Mr. Jordan?
I was trying to catch up on the bond orders. Was there a stay away on this case?
Yes, he's got to stay away from 1829 Campbellton. He can come one time with LEO to get any items.
Thank you.
All right. Best of luck to all parties concerned. Who do we have next?
Position number 8, Mr. Hernandez.
All right. Good afternoon, Mr. Hernandez. Your case is 24 CR 0067114G. You're charged with theft by shoplifting. You understand your rights? All right, Mr. Howard.
24. He was arrested for burglary this year in the first degree, criminal damage to property, second degree, simple battery against police. That's 24 PI 004921. Got another 24 PI case for sale of marijuana, 24 PI 004903. Open case out of state court. Bicycle written on wrong
You
side of
said
the roadway.
bicycle? Oh,
Yeah,
road.
that's what they
Okay.
got on here.
Bicycle.
Open giving false name. 24 CR 004569G. 2021 FTA and 2019 FTA.
Okay. Thank you. Ms. Allen?
Thank you, Your Honor. This is an incident that occurred on the 24th between 11 a.m. and about 1 p.m. at 880 Holcomb Bridge Road in Roswell. The defendant was accompanied by another person, a woman named Natalie, and on surveillance, they were seen entering into Madeline's hair salon at that location, helping themselves to refrigerated drinks and snacks for sale, and then leaving very quickly. So you've got a count of shoplifting, Your Honor. The gentleman in front of you was captured on surveillance. He was known and is known to the police at the location and in and around the location, as well as the people at that store. He has.
This is a hair salon. I'm sorry, Ms. Allen. I'm just trying to make sure I understand. This is a hair salon.
Some people need snacks. Some people need snacks.
And it was open at 1 and the time again?
It is 11 and 1 p.m., 11 a.m. to 1 p.m.
Oh, okay. I was thinking, okay.
Not in the middle of the night.
Okay. All right. Please continue. Thank you, Ms. Allen.
This young man has a pretty significant criminal history. I would note that he's got 5 prior convictions that although they were separate and separate dates, he was allowed to do PTI and a conditional discharge as well. It wasn't until 2019, that he actually got a felony conviction. These are all for possession with intent and possession of a firearm during the commission. He currently has 4 open cases that you just heard about, including felony level drug in Superior Court and a burglary. He was just released from jail there in Fulton County on August the 22nd, Your Honor. So the court should be concerned that the risk to reoffend is large. There is obviously a substance abuse or mental health issue going on here. Although stealing $10 worth of snacks is blatant and brazen. This is not the worst crime in the world, but there's an issue here and somebody should advocate for this young man. We'd ask for a $1,000 cash bond to be ordered to stay away from the location at 880 Holcomb Bridge Road. That's Madeline's Hair Salon, and no drugs, alcohol, or weapons. We'd also ask for a BHET.
Okay, Mr. McLean?
See if I'm off mute. Yes, I am. I know it's too early to ask for a bill of particulars, but do we know what snacks and how much each one was? It's $10. Are we talking about $3 snacks? Are we talking about
I'm so
$2?
glad you think this is funny. Let's move on.
Not joking about it.
No, it's not that it's funny.
It's less than $500.
Sorry, Miss
It's
Allen,
interesting. If nothing else. No one's trying to be funny, Miss Allen. I think we're all just surprised at the facts here. They are interesting. All right, Mr.
We
McLean,
have
please.
a theft of less than $10 very frequently.
Understood,
People
but
are arrested for being somewhere when they're not supposed to be there.
it's a hair salon and the food products are there. Were they marked? Are y'all?
Yes, they're for sale, sir. They're for sale. I'm sorry, this is confusing.
Right.
Yeah.
Were they marked? Do they have
You don't
a
need to
price?
be confused. Items for sale were
Okay.
stolen. It's on
Was there-
surveillance.
Was there a sign? I guess we need the
I
surveillance.
look forward to talking to you about this case further.
Okay.
All right, we're all pretty riled up over this. Let's all.
No, I don't understand why this is an issue. Like,
No, it is interesting, Ms. Allen, because it's not a place to be honest, you don't expect snacks at a hair salon. You
they're
don't.
not snacks when you check out at Old Navy or snacks when you're
There,
at.
there are. That's why we had to ask you.
All for sale.
When I in fact asked, was it, a hair salon with snacks? It was just interesting. All right, Mr. McLean, please
I would
proceed.
just, I guess, expect that with all due respect and candor to the court, you would understand that I've reviewed these facts. And if I present to you that this is a theft, I haven't made a mistake.
No
And
one
I'm
thinks
not trying to
no one is
perpetrate a fraud on
accusing.
the
No,
court.
Miss Allen, let's stop. No, not one person is accusing you of a mistake. We
It's
just
very
wanted to
interesting
clarify that it was just unusual. That's all. And
Why don't we
usually
do some advocating for this young man? This is the person everybody's attention should be on right now.
So it is
Thanks for telling me what I should do, Miss Allen, but I don't mean to frustrate you at all. But
I'm not talking to you about it. I'm talking to Mr. McLean, who thinks this is a joke.
No, I don't think it's. It is possible that a person can walk in.
Can you please just do your job and work on your client?
Thank you.
We're all very upset. Let's keep going.
It's possible a person could walk into a hair salon and if things aren't marked, they could believe they were complimentary. That's possible. Considering that, I would ask the court to give him a signature bond.
Okay. In light of information before me, defendant is going to receive $1,000 surety bond. He is absolutely to stay away from that location. What was it again? 880 Holcomb Bridge Road. And he's having no alcohol, drugs, or weapons. He is going to all purpose on 10. Best of luck to you, Mr. Hernandez. 1,000 surety.
Thank you.
All right. All right, let's go now to do we have position 14, Mr. Wright?
Mr. Wright, via a waiver, Your Honor, I spoke to him and he asked me to sign.
So let's do that waive case. We're going to take up 24 CR 00672-6H, in which the defendant is charged with simple battery, family violence, and battery, family violence. This case has been properly waived by counsel. Mr. Howard?
8 total. 2024 criminal damage to property, given false name. Obstruction, that was dismissed. 2023 obstruction, given false name. 2023 trespass. 2017 shoplifting conviction. 2017 shoplifting obstruction conviction. And 2012 criminal damage to property, theft by taking PTI.
Okay.
This is an incident that occurred on the 24th of September at about 9 p.m. Police were called to 716 Charlotte Place. This is a mental health issue, Your Honor. The victims in this case are the defendant's mother and grandmother. Charlotte Harris is his grandmother. He struck her in the head with an object, causing a swelling. Carlethia Wright is his mother. He shoved her multiple times in the chest. They all lived together at the location. They reported that the defendant was experiencing a mental health episode and being violent. He was destroying things in the house. He also was observed to have cuts all over his hands because he'd been punching glass and injured himself. The two cases that you just heard about, a criminal damage to property in the second degree in Superior Court, as well as two cases from 2023 for criminal trespass and false info, were actually just dismissed or null prossed in May, Your Honor, because there's a competency issue with this young man.
Okay.
So the state would be asking for a $2,000 surety. We've tried to get in touch with the family this morning, but there's obviously a safety issue. No drugs, alcohol, or weapons. Stay away from the location and have no contact with these ladies, and a mental health evaluation, or he needs to go on the competency track. And if medication compliance is applicable, that would be something we'd like to see as well.
Okay. He's had the evaluation, and the null process was based upon that evaluation in the past.
Two of the null
Okay.
orders that I just looked at literally say his lack of resources, his competency. He's been on the competency track.
Count
There are orders
for
related.
so that that old eval needs to be attached to these cases. Okay, Mr. McLean. Well, first let's down for any alleged victims. Are the alleged victims' mother or grandmother of the victim present? Just to make sure. Seeing none, hearing none. Mr. McLean.
Your Honor, I don't have much to add. It was just with the victims being, with the alleged victims being his family, and with the recent findings of incompetence, I agree that if those things are too old to be, we need a fresh evaluation unless they're fresh serve. So
Do we know? We probably don't know how old it is,
right?
Especially if those are older, but
the incidences were from 2023.
So they're probably still valid. Okay.
So I don't have anything to add, Your Honor, as far as the bond, whatever the court feels is appropriate, and I'm sure he'll be back on SAP, and by then we'll certainly have a social worker visit him.
Okay. So if he's going to get a $3,000 surety, $1,000 on the simple, $2,000 on the battery family violence. He's have no contact with either of the alleged victims, and stay away from that location. Have no alcohol, drugs, or weapons. We will put him on SAP for now, but require a social worker visit and see if we can associate the old eval, if it's not too old, with the current case, if possible, such that if necessary, he can go to the other calendar. Is that SAP date? Is that 10th a Thursday? Or is that a Tuesday?
It is a Thursday.
It's a Thursday, so that's fine anyway. So that matter can be addressed both ways.
Thank you.
All right. I think that's the entire SCA calendar. Is that correct?
What are we doing tomorrow?
We're not having court, and we'll pick up on Saturday. Judge Law will address first appearance at that time for anyone who should have been on tomorrow.
Okay. Could I address you in the court if somebody's in court? I missed this. I've been bouncing around. Officers, what is going on? I'm sure you told me before, but I've been up since 5:30, just working. The Cortez Wright, what's going on with Cortez Wright?
That's the one we just waived and just did. Mr. McLean just represented him.
Oh, I'm sorry. He was on my initial list. Thank you.
All right, Mr. Jordan, will you review the calendar for me?
Sorry, I have a question.
What's the question?
Will it be you on Saturday or no?
Not me.
Great.
Okay.
Oh man, you missed out, Saint Saran.
I'm sorry, it's not me. All right. Can we review
He's
calendar?
watching the Tech game Saturday. I don't even know who they're playing.
Yeah, we can hear you, Michael.
Okay. Position 1 is a $2,000 sign-on bond pretrial level 1, 1,000 per charge. Position 2 is a $3,000 sign-on bond pretrial, 1,000 level 1, 1,000.
I can barely hear.
Yeah, I don't know what's going on with my phone. I mean, my computer. My phone rang earlier and it messed up the volume. Is that better?
No.
It's a little better. We can kind of hear you.
This position 2 is a $3,000 sign-on bond pretrial level 1, 1,000 for count 1, 2,000 for count 2. Position 3 is reset to the SAP. He has a felony hold. Position 4 is a $2,000 surety bond, 1,000 per charge. Reset SAP. Position 5 is a $1,000 surety bond, reset SAP. Position 6 is a $3,000 sign-on bond pretrial level 1, 1,000 per charge. Position 7 is a $3,000 sign-on bond pretrial level 1. Position 8 is a $1,000 surety, reset SAP. Position 9 is a $8,000 surety, reset SAP. Position 10 is a $35 cash bond, reset SAP. Position 11 is a $1,000 cash bond, reset SAP. Position 12 is a $3,500 surety bond. Sorry. So position 10 was $5 cash on each charge. Position 11 was a $250 cash bond on each charge. Position 12 is a $3,500 surety bond. That's $1,500 for count 1, $500 for counts 2 and 3, and $1,000 for count 4. Position 13 is a $2,000 sign-on bond pretrial level 1. And position 14 is a $3,000 surety bond, 1,000 for count 1, 2,000 for count 2, and that's reset SAP.
Any comments, changes, corrections, questions, otherwise?
Thank you, Mr. Jordan.
Nothing at all.
All right. We will be in recess. As a reminder, there is no SCA tomorrow. We'll be in recess until Saturday's SCA calendar. Take care, everyone. Stay
Oh,
safe.
there is no SCA tomorrow?
There's no SCA tomorrow.
Wow. I get
They're
the
gonna-
news late.
They're going to
Did Lindbergh make it? I'm sorry. Sorry, that's an old joke. Okay, I'll talk to you about it.
Position 10 is a $35 cash bond. She got $5 cash on each count. She had 7 counts. 7 times 5, just checking my own mental math, is 35. All right, everyone, take care. We will be in recess again. You all gave me a run for my money. Take care, stay safe.
Okay.
Enjoy
Go
the
Braves.
stay dry.
We
Take
need
care, everyone.
everybody pulling.
Bye-bye.
Thank
Bye.
you.